Right. So, what the corporate law? Basically, we are going to discuss about the provisions contained in the Companies Act. Number 7 now, 2007. So this is the prevailing law in Sri Lanka regarding companies. Right. So this is the prevailing law regarding companies. Now under corporate law, basically we are going to discuss about how to incorporate a company under the Companies Act. Right. Now before coming to corporate law, when we consider the concept called person, right? Person, according to law, we can identify there are two types of persons. Who are the? There are two types of persons recognized. Who are? What persons recognized by law? Male and female. There are two types of persons. One means natural person. Right? So male, female, all are right included to this category. Right? Legal person. Legal person. Legal person. There are two types of persons recognized. Then when we consider the natural persons, they are human beings, right? They are human beings. But when we consider the legal persons, actually they are created persons. Created persons, right? Created persons are named as legal persons. We can create a legal person by two methods. Right? One is Parliament can bring an act declaring a particular organization as a legal person. Right? Particular organization can be recognized as a legal person. There are several examples like foreign employment, legal person, like incorporated by an act of the Parliament, by a GOC, People's Bank. They are the establishment, right, recognized as legal persons by acts of the Parliament. Right? Parliament can bring an act declaring particular organization as a legal person. And the second method is that is we can incorporate a company under the Companies Act. Incorporate. Incorporation. By incorporation under the Companies Act. Right? The proper word is incorporation, right? My handout it is written as registration. The registration under the Companies Act. Actually, there is no registration. It is incorporation. The incorporation under the Companies Act. You can incorporate the company under the Companies Act. Then after incorporation, that company is treated as a legal person. That is the second thing. Now actually under corporate law, we are discussing about how to incorporate a company under the Companies Act. Right? Two persons, natural, legal. Legal persons are created persons, artificial like persons. So we can create a person by two methods. Like one is Parliament can bring an act declaring a particular person as illegal. And the second method is incorporate under the Companies Act. You can incorporate a company under the Companies Act. Understood? Right. Now, when we consider the incorporation, what are the companies can be incorporated in Sri Lanka? Yes. These are common. Yes. Only. Yes. What are the companies? Yes. What are the companies can be incorporated in Sri Lanka? Yes. What are the companies can be incorporated? Yes. How many types of companies can be incorporated? Basically, we can identify three types of companies can be incorporated. Right. Now, when we consider the company, right? Three types of companies can be incorporated under the Companies Act. Right. One is limited company. And an unlimited company. Unlimited company. Right. Unlimited companies and company limited by guarantee. These are the main types can be incorporated. The Companies Act. Thereafter, when we consider the limited company, we can divide these companies into two. That is public companies and private companies. Public and private. Then thereafter, we can divide public companies into two. And public companies we can divide into two. We can further divide into two. As listed and unlisted. Listed, unlisted. So what is the difference between listed and unlisted? Listed and unlisted. Listed companies, they can trade their shares on the stock exchange. But the unlisted companies, they don't have that privilege. Right? They can trade their shares on the stock exchange. Listed and unlisted. Then, apart from these types, we can recognize some other types of companies. Right? That is offshore company. Offshore companies. Right? And another type we can recognize overseas companies. Right? Overseas companies. Offshore companies and overseas. Overseas companies. Right? So we can identify listed, unlisted, private, unlimited, and companies limited by guarantee. Right? Companies limited by guarantee. And thereafter, offshore companies and overseas companies. So altogether, there are several types of companies. We can recognize, like incorporated, right? Now, actually, these are the companies can be incorporated under the companies. Incorporated. Like when we consider offshore companies or overseas companies, right? They are not incorporated in Sri Lanka. Right now, when we consider offshore company, right? This company may be incorporated. That is the word. Incorporated in Sri Lanka. Incorporation. Incorporated in Sri Lanka or abroad. Incorporation in Sri Lanka or abroad. And doing their business. Incorporated, these companies are incorporated in Sri Lanka or abroad. Doing their business abroad. Right? Doing their business. That is the main feature of the offshore company. Right? They don't have any authority to do any business activity in Sri Lanka. Offshore company. Offshore company. Then overseas company, they are incorporated abroad. This one. Overseas company, they are incorporated. And when they are business, so they have right, an established place of business in Sri Lanka. That is that. Right? The main features of overseas companies. They have an established place of business in Sri Lanka. Business in Sri Lanka. Right. So that's why I have made a mistake. You see, right? Another thing we have to include is like under offshore company, is incorporated in Sri Lanka or abroad, right? And registered as an offshore company under the Companies Act, right? Registered under the Companies Act. And doing their business abroad. Basically, we can identify three features. It is incorporated, like Sri Lanka or abroad. Right? Registered as an offshore company under the Companies Act. Registered. That's why I told you registration and incorporation two different concepts. This is registered as an offshore company. Companies Act. And doing their business. They are not permitted to do any business activity. That is offshore company. But overseas company incorporated abroad. And doing their business in that is about the overseas company and offshore company. Therefore, actually, we cannot consider the offshore company under these. Maybe incorporated in Sri Lanka or abroad. Right? Maybe incorporated abroad. Right? But only thing is we can identify registration. Registration is in Sri Lanka under the Companies Act. Registration. And doing their business. Right? So when we consider these are the companies can be incorporated. Right? Basically, it's that unlisted private, unlimited that companies listed, right? So these are the types of companies that we incorporated in Sri Lanka. Apart from that, right? Other two companies we can recognize also may be incorporated in here or abroad. And overseas companies, definitely they are incorporated. So these are the types. Right? Then thereafter, now suppose you are going to incorporate a company under the Companies Act. Then what are the documents to be submitted to registrar of companies ROC? Registrar. What are the documents to be submitted? Form 1. Form 1. Then what else? Form 30. Director's consent. That is Form 8. Form 8. Consent of the initial director. Then after change you can consent 4. Right? Consent of the initial directors. Then Form 90. Form 1 is the application form. Then thereafter you have to submit articles of association of the company. Articles of association. Right? Articles of association of the company. This is the constitution of the company. Constitution. Then thereafter, Form 80. This is the consent of the initial directors to act as the directors of the company. Form 80. Then thereafter, Form 90. Form 90. This is the consent of the initial secretary to act as the secretary of the company. Another form we have submitted is named as Form 16A. Form 16A. This is a name approval form. Name approval form. First, we have to select name for the future company. Then we have to get approval from the registrar of company. So if the name is approved, then name approval number is given. I think it is mentioned in the form 16A. So 16A name approval form. Right. Basically, we can identify these are documents. 5 documents submitted. Register company, single incorporate a company under the company set. Right. First one, name approval for 16 million. Yes, start. No, 16 million. Right. Then form 1 is the application form and articles of association. Copy of the article of association. And Form 80, consent of the initial directors, as directors of the company. And Form 90, consent of the initial secretary. So, attach the secretary of the company. Right, 5 documents to be submitted. When we consider the, right, so these are the documents to be submitted. When we consider the application form, right, this form, application form, to be signed by all the initial shareholders with a declaration. With a declaration. What is the declaration? Right, declaration is to the best of their knowledge, the name of the company is not identical or similar. Identical or similar. Identical or similar to an existing name of a company. Existing name of a company. That is the declaration to be given by the initial shareholders. Right. They have mentioned to the best of their knowledge, the name is not identical or similar to an existing name of a company. So here there are 2 words. Identical means just sameness. Just sameness. Similar is it is almost same. Right, 99% same. That is similar. Now when we consider identical, suppose the first registered company, name of the first registered company is Bata. Then the second registered company's name is also Bata. This is identical. Identical. Just same as. Right? And Bata. The second company is Bota. 1 letter missing. Instead of A, O mentioned. This is similar. This is similar. Right? But identity is right? Identity. It's a website. Right? Just same length. Right? But this is similar. So, what is the declaration? To the best of their knowledge, name is not identical or similar to an existing name of a company. Right, so there is a declaration to be given by the initial shareholders for 1 application. Right, thereafter, very important document, the second document, third document, is the name approval, application form, and articles of association. Articles of association. Right. So, in order to incorporate a company under the Companies Act, right? That company, applicant must submit a copy of the articles of association of the company. Right? So, with regard to this requirement, actually, the company can adopt 1 option out of 3 options. Actually, there are 3 options available to the company. Right? Company can adopt 1 out of the 3 options here. First one is company can prepare its own, right? Its own set of articles, right? Or new one. New articles of association they can prepare, but it is very difficult. Right? Now, this is like articles of association is looked at as the constitution of the company. All the internal, external, the provisions with regard to management, administration, rights, privileges of the shareholders, right? The objects of the company, all the right internal regulating provisions to be included in the articles of association. Preparing a new one is a very hard task. Right? New and very comprehensive articles of association. Right? It's very difficult task. There are actually another two options given. Right? Second option is there is a model set of articles. Model set of articles set out in the first schedule to the Companies Act. Now, when you are considering the Companies Act, there are several schedules attached to the Companies Act. So, in the first schedule to the Companies Act, there is a model set of articles set out. Right? A model set of articles set out in the first schedule to the Companies Act. It's a model. It's a model set of articles. Right. Then actually company need not to prepare new articles of association. Only the company just mentioned they are adopting the model set of articles set out in the first schedule to the Companies Act. Therefore, they need not to copy this document. They are adopting the model set of articles in the first schedule to the Companies Act. So this is the right very convenient option given to the applicant. They need not to submit new one. Right? They need not to prepare their own articles of association. Yes, they have to adopt the model set of articles. And the third option is company. So the applicant can alter the model set of articles and adopt. Right, alter one. Alter the model. And another option. Right. So if the model set of articles is not 100%, right, suited to your company, you can right change the model set of articles and adapt it. Like the amended articles of association, they can adapt. That is the third option. Right, so that is regarding the articles of association. Right, articles of association. ඒකට කියන්නේ අනිවාර්යෙන්ම දාන්න ඕනේ. හරි. පැහැදිලි මේ ඔඩි කියන්නේ නිකන් ආකෘතියක් තියෙනවා. කොයි එකකත් හරියන ඕකටත් හරියන ව්‍යවස්ථාවක් තියෙනවා. ඒක කියන්නේ ව්‍යවස්ථාවක්. හරි. ඕක ගොඩක් සමාගම් වලට ගැලපෙන ව්‍යවස්ථාවක් තියෙනවා මේ පළවෙනි උපලේඛ පස්සේ कंपनी आपकी अदाल कर मेंशन कराने गोडाकाय सामान ಈಗ ಇದ್ದಾನು ಸಮಾಗಮಕ್ಕೆ ಮಹಾದಾರ ಸಮಿತಿ ಅಂತಂದ್ರೆ ನಮಗೆ ಜಾಬಿ ತಗೊಟ್ಟ ಮೇನ್ಲಿ ನಮ್ಮ ಆಪ್ಷನ್ಸ್ තුනක් තියෙනවා එකක් තමයි ඔයාටම පුළුවන් හිතලා ව්‍යවස්ථාවක් හදාගන්න. ඒක සමාජිකයෝ කීයද සමාජිකයෙක් මලොත් කීයද පවුලෙක් කෙනෙක් මලොත් කීයද සමාජික මුදල කීයද අර ඒක ඔය කියන අප්පන් නැනක් ආවෙන්න ඔයාට පුළුවන් එකක් හදාගන්න. ඒක ටිකක් අමාරු වෙනවා. ප්‍රිපෙයාරින් දිනුවා. අර එහෙම නැත්නම් ඔයාට පුළුවන් ඊළඟ එහාගේ තලක තියෙනවා නම් මේ වගේ මහානාදාය සමිතියක් ඒක අරගෙන ඉන්න. අරගෙන ඇවිල්ලා නම් විතරක් වෙනස් කරන එක ඒක අඩක් කරනවා. that's the model. ඒ ඉස්සෙල්ලාදී ඒක. හරි. අල්ලපු ගම එකක් තියෙනවා. ඒක අරගෙන අපේ නම දාලා අපි හදාගන්නවා. Really, then you need not submit your own one. Just you have to make sure we are adapting the model set of R. They already read. Anyone has come around? एक model लेगा model change करा. अरे एक और टाइप की आपने model बिना से right. So that is the reason. So incorporation is very simple, in fact, because of these options. Thereafter is the consent of the initial director. Right? They have to give their consent to act as the initial director of the company. And Form 90, under Form 90, initial second, right? They must give, he or she must give the consent to act as the initial secretary of the Form 18 and 9. Right, so these are the documents. What are the documents? 16A. First, we have to get the name and plural. 16A. End of it, 16A. Application form, Form 1, and articles of association, Form 18, Form 9. 5 documents. Then thereafter, so we have to submit these documents to the registrar of company. Then the registrar of company are those shall enter the particulars of the company on a register. Right. Then thereafter assign a unique number. Unique number to the applicant company. It is named as company. Company number. Assign unique number to the company. Right. You can identify when the company engaging into documents like deeds, then they mention their number like PV 1085. Right? So this is the number, company number. So register, he shall assign unique number to the applicant company with name as company number. Then the very important thing is, that is, the registrar shall issue a certificate of incorporation. Certificate of incorporation. Certificate of incorporation. Right. Now, when we consider certificate of incorporation, right, this is right, treated as the birth certificate of the company. Birth certificate. Right. Now, there are two types of persons, natural persons and legal persons. In natural persons, their birth certificate, what are the particulars mentioned in this certificate? Name of the person. Okay. What else? Date of birth. How long certificate? When are the natural persons? Place, name, place, and date of birth. Sex, male, female, we have mentioned, right? You know what I mean? So here also say, you have in the articles of certificate of incorporation, not article, right? Certificate of incorporation, right? They have to mention the name of the company, Right? Instead of date of birth, here date of incorporation. Date of incorporation. And instead of sex, natural persons, here they have to mention type of company. Like which type? Private, public, right? What is the type of company? So, likewise, right? So, these are the particulars to be mentioned in the certificates of incorporation. Right? So, only thing is, right, assign unique number is also very important, right? And the registrar can issue a certificate of incorporation to the applicant. Certificate of incorporation. So when we consider this number, company number, that is very important. After incorporation, company can change its name. Company can change its name by passing special resolution. Company can change its name, but this number cannot be changed. Right? So it will remain in the company until the winding up of the company. Until the winding up, that is the end of the company. It will, right? You cannot change the number, company number. Right? Then certificate of incorporation. Person. Certificate of incorporation. Certificate of incorporation. After issuing certificate of incorporation for the company, this certificate is treated as. Now we are going to discuss about the legal effect of certificate of incorporation. Legal effect of certificate of incorporation. Right? So this certificate of incorporation is treated as, right, conclusive evidence. Conclusive evidence. Or in other words, right, conclusive evidence, or we can say irrebuttable evidence. Irrebuttable. Irrebuttable evidence. Irrebuttable means you cannot disprove. You cannot disprove. You cannot challenge. Challenge. Right? So conclusive. So irrebuttable. You cannot challenge. Right? Irrebuttable evidence of two things. The certificate of incorporation is treated as the conclusive evidence of two things. Irrebuttable evidence. It means you cannot change, you cannot challenge. By giving evidence, you cannot disprove. Right? Conclusive evidence. Right? The first thing is, right, the company has taken all necessary steps in order to incorporate it under the company. Company has taken all necessary steps. This is the first conclusive evidence. Company has taken all necessary steps in order to incorporate it under the company's act. Right. Now, suppose in the incorporation process, a particular step is not taken by the promoters. Right? Promoter is a person who is taking necessary promoter. Promoter is a person who is taking necessary steps in order to incorporate the company under the company standard. Right? So, due to negligence or otherwise, a particular step is not taken by the promoter. Right? However, the certificate of incorporation is issued to the company. Right? It is treated as irrevocable evidence or conclusive evidence that the company has taken all necessary steps. Therefore, even though a particular step is not taken by the promoter, it does not invalidate the incorporation of the company. Understood? It does not invalidate the incorporation of the company. Nobody can challenge this particular step is not taken. Therefore, incorporation is invalid. Right? So, like, nobody can challenge, nobody can argue. The only thing is we have to prove certificate of incorporation is issued to the company. Then it becomes like an irrevocable evidence that the company has taken all necessary steps in order to incorporate it under the company act. Right? So that is the view. Right? So actually, even though a particular step is not taken, it does not affect to the validity of the incorporation. Right? It is not affected. All the steps are taken. That is the conclusive evidence. And company came to an existence. Came to an existence on the date. Right, on the date mentioned in the certificate and not any other date. Right? On the date mentioned in the certificate of incorporation. In the certificate of incorporation. Not any other case. This is the conclusive evidence. It came to an existence on the day mentioned in the right certificate of incorporation. Now, as the birthday here, date of incorporation to be mentioned with the certificate of incorporation. Now, suppose according to the certificate of incorporation, right, it is mentioned the date of incorporation is 10th of January 2020. This is the date mentioned in the certificate. Right? Some of actually this company is incorporated on 15 January 2020. It's also January 2020. There is a date mentioned on the certificate. This is the actual. This is the actual. Actual. Right. So which date to be considered as date of incorporation? Yes. Actual date or date mentioned in the certificate. The date mentioned in the certificate. That is irrevocable evidence. By giving evidence, nobody can challenge that. If the date mentioned in the certificate as 10th of January 2020, so that is the date of incorporation. Right? Company came to an existence on the date which is mentioned in certificate and not on any other case. Right? So in a particular case, In a particular case, Lanka this is a company. This company, it is incorporated. This is the actual date, right? It is incorporated on 15 January 2020. This is the actual date. However, erroneously, this date of incorporation is mentioned in the certificate of incorporation as this company is incorporated on 10 January 2020. This is the date mentioned in the certificate. Certificate of incorporation. Certificate of incorporation. According to the certificate of incorporation, date of incorporation is 10 January 2020. But actually it is incorporated on 15 January 2020. Now, on this date, 10 January, this company has issued some shares. Then a person, B, he has purchased shares. He applied for the shares. Then thereafter, he came to know about this error. This actual date 15 January, but erroneously they mentioned in the certificate as 10 January. Right? Then thereafter, after he came to know about this error, then he refused to pay for the shares. He refused to pay for the shares purchased by him. Right. Then what happened? The company filed an action against he in order to recover the price of the shares. In order to recover the market, company filed an action. Then in the action, he made an argument. What is the argument? Right? This company is actually incorporated, right? Actually incorporated on 15 January 2020. This is actual. Therefore, this company cannot issue shares on 10th of January. Right? The company cannot issue shares on 10th of January because on 10th of January there is no such company. It is not in existence with contractual capacity to issue shares. So, right? Actually, it is incorporated on 15 January. Right? Then he refused to, on this ground, he refused to pay for the shares. Right? So this is argued. Right? Then actually court has to decide, right, which date to be considered as date of incorporation. Right? So after issuing certificate of incorporation to the company, right, one conclusive evidence is company came to an existence and the date it is mentioned in the certificate of incorporation and not on any other date. There is conclusive evidence. Nobody can challenge. Nobody can. By giving evidence, nobody can disprove that. Right? Nobody can challenge. Nobody can change that. Therefore, court held, right? What is the date of incorporation of this company? That is the date mentioned in the certificate of incorporation. Right? Therefore, this company is also incorporated on 10th of January. Right? Then this company can issue shares on 10th of January. Therefore, right, he has to pay for the shares. Right? So that is the meaning of conclusive evidence. Nobody can challenge. By being real evidence, this is the real situation like that. Nobody can challenge it. Nobody can challenge. That is the meaning of irrebutable. In the hell and the back. In the hell, no hack. Happy Samara, you know, it's a stoker of prayer. I mean, there is no way to get and irrebutable is you. In the hell and the back. In the hell and the back. So nobody can, by giving evidence, nobody can challenge the this evidence. That is the minimum conclusive evidence. So here, two conclusive evidence, right? Claims, right? Certificate of incorporation. The first one is company has taken all necessary steps. Right? All necessary steps, and company came to an existence on the day which is mentioned in the certification, and not on any other. Right? So there are two, yes, conclusive evidence or irrevocable evidence. Right? We can consider with regard to certificate of incorporation. Only thing is we have to consider whether the certificate of incorporation is issued to the applicant. And nobody can challenge this. Understood? So these are the documents to be submitted to the registrar. There are 5 documents. 5 documents. And thereafter registrar enter the particulars register. Thereafter sign unique number. Right? The identical number to the company, so unique number to the company. Then, company register shall issue a certificate of incorporation to the establishment. This is the legal effect of certificate of incorporation. Then thereafter, right now, because we have some big documents, then certificate of incorporation issued. Right? Then, after incorporating the company, after incorporation, the company shall give a public notice. Public notice. The public notice of its incorporation. And the name Samagama Kriyapati Sansthagat කරනවා. එහෙම සමාගමක් සංස්ථාගත කරනවා. ඒක තමයි වචන. ක්‍රියාපති කියන්නේ registration. Incorporation කියන්නේ සංස්ථාගත. හරි වචනේ මොකක්ද? Incorporation, not registration. Offshore companies registered as an offshore company. Incorporated here or abroad. Right? Therefore, this is incorporation. So after incorporation, this company shall give a public notice of its incorporation. How this company can give public notice? මහජනයාට කොහොමද මේක දැනුවත් කරන්නේ? මේව සමාගමක් අපි public notice. How this company can give public notice? So after incorporation, within 30 working days, so you have to exclude holidays. You have to exclude holidays. Within 30 working days, this company shall give a public notice of its incorporation. How company can give public notice? The ඔයගලන්ට රටේ ඉන්න අයට කියා ගන්න දෙයක් තියෙනවා නම් මොකද කරන්නේ? රටකම දැනුම් දීමක් කරන්න ඕන නම් මොකද කරන්නේ? You can publish an advertisement in a daily newspaper. Right? The daily newspaper in 3 languages, Sinhala, Tamil, and English. This company also, right? Have to publish an advertisement in a daily newspaper in 3 languages. Right? By mentioning 3 particulars. Name of the company. So in the advertisement, they have to mention the advertisement name of the company. Right? And company number. Right? Unique number. Right? And address of the registered office. Address of the registered office. So these are the particulars to be mentioned in the advertisement. Right? Name of the company, unique number, company number, right? And address of the registered office of the company. Second, two the name of that. So there is the public notice. Anything that? Yes, why public notice to be given? This is given to public people. Right? Why public notice to the public? Yes. Hey, Mahajane, then what? Name of Samag, when the name of you have to mention the name of the company. Yes. The main reason is now suppose the company is already incorporated. Again, it is identical or similar to the name of the company. The first company is already right, incorporated by name, but suppose the second company, the newly incorporated one, its name is also part. Then identical, name is identical. Or similar. The first company Bata and the second company is more similar. Then first registered company can make an application to register of companies. ROC. Within 3 months' time from the date of this public notice, within 3 months' time, the first registered company can make an application to register companies, stating the second registered company's name is identical or similar, right, to our company's name. So that is the allegation made against the second registered company. Name is identical or similar. Right? Then registrar can direct the second registered company to change the name. So for this purpose, they have to mention their name and the company number and identification number and the company number and the address of the registered office. The address. Clearly can identify what is the company, what is the address, and what is the name. The first registered company can make an application to register if the second registered company's name is identical. In 3 months' time, they can bring into the notice of the registered company. First, the second company's name is identical. If they are after register, can directly come to change. And very important thing is if such direction is given within 6 weeks time, that is 6 weeks, it means 1.5 months. Within 6 weeks, within 6 weeks, the second registered company shall change its name. Right? Otherwise, the company shall be guilty of an offense. Right? On conviction, be liable to pay a fine 200,000. Right? That is the punishment because the second registered company. It is not compliant with the direction given by the registered company. Right? So within 6 weeks' time, the second registered company shall change its name. Right? So for that purpose, actually, after incorporation, within 30 working days, this company shall see public notice. Right? Right now, when we consider documents to be submitted, certificate of incorporation is issued, then public notice within 30 working days. And thereafter, after publications, like within 60 working days after the public notice, 60 working days after the publication, after the public notice, a proof of the publications to be submitted to the registry. Proof of the publication. Proof of the publication. කොපියක් දෙන්න ඕනේ රෙජිස්ටර්. එතන දෙන අපි මේක දැනුම් දුන්න මහජනතාවට. and proof of publication submitted to the registrar within 60 working days after the public notice. So that is the procedure of incorporation. Procedure of incorporation. Right. Documents, certificate of incorporation, public notice, proof of the publication. We can add in the post-case and right. Now we get how you are not again accept the company will be guilty of an offense. Aparadhena verdicare. Aparadhena verdicare, the punishment is the fine must not exceeding 200,000. Same idea, yeah. But the company can do that, right? So you are very happy that we are not. If the company shall not comply with the direction given by the registrar, then company shall be guilty of an offense. It is an offense. On conviction, be liable to pay a fine not exceeding 200,000. Fine is not exceed. Exceeding 200,000 rupees. 200,000. So last day के क्या बने ना? last day के क्या बने ना? और conviction, be liable to pay a fine not exceed. This is the fine. दाड़िये तमारी. अपनी नीतियाँ interpret करने के लिए पढ़ते जाना fine is not exceeding 200,000. Not exceeding can exceed therefore even 500,000, 5,000 is also right within this scope. Not exceed. Make find the idea again. It is first time 5,000, 10,000, right, or 20,000. Maybe 200 is a discretion is given to the judge. Yeah, the far direction. You are getting the Adhikarya. It was over Gilhama, Adhikarya, not exceeding. Not exceeding. In some cases, we can recognize minimum punishment. Minimum 200,000, maximum 2 million. The minimum. That is the lower limit of the punishment. He may not be. He may not be. They 200,000 that is the punishment, not to exceed 200,000. This is the first time 5,000 rupees. Then the fine. 10,000. Right? Even now it's about. People bar and have the car. Nothing on me. Okay. They would come and balance their value. They were the right. The Miwagi, they may Saman. But we could not be so. So tell us that the car right now. I'm going to get idea of business. You have a call kind of work. People are the things like, you know. They got to go on Madara and say, I park. I want to run the Kuruna, that is you. That is what I guarantee. Chance accept it. You never can have a man. The last thing they gave that I got. Victor, कोई तो रेडी आर्ट को लास्ट से आते देखा अपने झाल दिन बढ़े देखा तो एक था मिनिमम पार्टिसिपेंट ये सही तो एक वाला आजू करा सुने चालू करके ये देखिए यहाँ पे मेरे ये प्रोडक्ट के नॉट पे एक्सीड इनसे पे किस तरह है ये फाइल है या दाह अपना बैकग्राउंड ये बना है The company is incorporated, right? Very important concept we are considering. Suppose A and B, A, B and C. Amal, Bimal, and Amal. You can identify they are natural persons. Natural persons. I told you there are 4 types of persons. Natural persons. Amal, yes. Yes, Amal, Bimal, and Amal. Natural persons. They have incorporated the company by name ABC Private Limited. This is the company. ABC PVT LT Private Limited. They have incorporated the company by name of ABC Private Limited. Right. So after incorporation, we can identify there are 4 persons. 4 persons, 3 natural persons. Amal, Bimal, and Amal. And 1 legal person. Right, that is ABC Private. Right. So after incorporation, we can identify 4 persons. 3 natural, 1 legal. Then this company, ABC Private Limited, they have borrowed 100,000 rupees from a bank. 100,000. Company has borrowed money from a bank. Then this is a private company, right? Private limited company. Then if the company defaults in payments, right, bank can file an action in order to recover the balance amount of loan. Right. Against whom bank has to file an action? Yes. Amal, Bimal, Kamal, Suppose they after incorporate, after incorporation, Aman, Jibal, Kamal, they are the shareholders of the company. As well as they are the directors of the company. They are the directors and shareholders. Right? And the company, ABC Private Limited, it has borrowed money. Then, if the money is not paid, then bank is going to file an action in order to recover the money. Against whom bank has to file an action? Yes. Against whom? Can bank file an action against someone? The shareholders are the owners of the company. Shareholders are treated as owners. And we can identify three parties. One is promoter. Promote. And shareholder. Shareholder. So we can say members of the company. Members of the company. Because now when we consider, I told you there are three types of companies can be incorporated. Right? Limited, unlimited, company limited by guarantee. In a company limited by guarantee, they don't have share capital. Therefore, no shareholders. They cannot issue shares. It is a company limited by guarantee. Therefore, shareholders and owners are commonly named as members. Right? Members. We can identify promoters, members, and directors. And suppose all the steps are taken by Aman, Bimal, and Kamal. They are the promoters of the company. After incorporation, they are the shareholders of the company as well as directors of the company. Company defaults in payments. Now the bank is going to recover money. Right. Against whom bank has to file an action. Can file an action against Aman, because he's a director, promoter, director, promoter, and shareholder. Can against Iman, Aman, right? Then bank has to file an action against ABC Private. So this concept is named as corporate veil. Right? Separate legal personalities. Separate legal personalities. Or veil of incorporation. Another name. Veil of incorporation. That is, after incorporating a company, then there's a veil. Veil can. There's a veil. Veil can Manamali Angeka Manamali Salamaru Dana veil. It's a all pain. Who pain veil darling. Better was I can. Veil of incorporation. Right? Veil of incorporation. After incorporation, there's a veil separating these persons from the company. There's a veil. Veil like separating Amal, Bimal, and Aman from company. There's a veil. Therefore, actually, the bank creditor for the third party, right? Third party cannot see beyond the veil. It can see only ABC Private Limited. Therefore, for the activities of the company itself responsible. Not the promoters, shareholders, or directors. Responsible for the activities of the company. So this is the corporate veil. Or separate legal person and the company. Right? After incorporation, the company is separate from those who, right? Those who create it. Those who create it. Creators are named as promoters. Creators. Those who Those who manage it, right? Who are managing the company? Directors. Those who manage it. Right? And it is separate from those who own it. Who are the owners of the company? Owners. So this concept is named as corporate name or separate legal personality concept. After incorporation, the company is separate from those who create it, promoters, those who manage it, directors, those who own it, right? Members. Therefore, for the activities of the company itself responsible, right? Self-responsible. Therefore, actually, bank, third party can bring an action only against agency. So this concept is there. There's a way separating these persons from the company. Therefore, third part cannot see who is behind the veil. Behind it. Right? Therefore, at the pain, the pain, behind the pain, it's a person, ABC private person, legal person, right? For the activities of the company itself responsible. Bank can file an action only against ABC private. It is the concept of corporate. Understanding. Right. Sale of incorporation. After incorporation, company is treated as a separate company. Those who create, those who own it, those who manage it. Separate legal persons from corporate. Now, actually, this concept is recognized by a first time in the legal history. This concept is recognized by a court in a particular case. Right? I think this case is known to you. Solomon versus Solomon Company Limited. Solomon versus Solomon Company. Solomon versus Solomon. Solomon versus Solomon. Solomon versus Solomon Company. This is the name of the company. This is the name of the owner. Owner of the company. Solomon, Mr. Solomon. Right. Now in this case, they concept Mr. Solomon, natural person. These are goods manufacturing. Popular. He's manufacturing goods. Sole trade proprietor. Right? Then he wanted to extend their business. Then he incorporated a company by name Solomon Company Limited. So this is the name of the company. Then he became the main shareholder of the company. Right. Main shareholder of the company. Right. Then thereafter, now the company is incorporated. Right. Company is incorporated. Then this company issued share debenture. Right? Debenture. Right. The company issued debentures. Right? All the debentures are secured on the assets of the company. Right? Secured debentures. Debentures are secured on the assets of the company. It means now in the event of liquidation, the priority to be given to the debenture holders. While settling debts, or while settling the creditors, the priority to be given to the debenture holders. Because the debentures are secured on the assets of the company. Correct. आयकर निकुत करना हमारे में वापस अपेयर दिए මේ මත තමයි ණය කරන නිකුත් සමාගමේ තියෙන ඇසෙට්ස් ඔක්කොම මේකට යටත්ව තමයි නිකුත් කරලා තියෙන්නේ. පෙරේරා සමාගම ඉස්රායල් first choice to be given to the debenture holders. ඒගොල්ලන්ගේ ණය ඉස්සෙල්ලා ගෙවනවා. සමාගම the event of liquidation actually what is the main procedure? Collect all the assets. Collect all the assets, realize them by using the proceeds. First, we have to settle the creditors. Then, if any amount remains in the company, it will be distributed among the shareholders. ලැබෙන සල්ලි වලින් ණය ගෙනියන්න දෙනවා. ඉතුරු වුණොත් ඒක සල්ලි අයිතිකාරයෙකුට බෙදා ගන්නවා. That is the end of the liquidity. Right? So here, among the creditors, priority to be given to the debenture holders because all the assets, debentures are secured on the assets of the company. Then not only that, the company has borrowed some other loans from third-party creditors. These creditors, they didn't take any security for the loan given. Debentures issue and loan is given by the creditors, the company, but the creditors didn't receive any security. Right? These debentures, all the debentures are purchased by Mr. Solomon. Right? That is the owners of Solomon. Colombo. Right? All the debentures are purchased by all the debentures are purchased by Mr. Solomon, owner of the company. He is the main shareholder, owner, right? The director, right? Then all the debentures which are secured on the assets of the company, right? Purchased by Mr. Solomon. And the company has, the Solomon Company Limited has taken another loan from third-party creditors. But the third-party creditors didn't receive any security, right, for the loan given. Then thereafter, after a short period of business, this company suffers heavy loss. Right? Then thereafter, the company is liquidated. But what happened after disposing all the assets, right? The company didn't have sufficient money to pay for the debenture holders and third-party creditors. No sufficient money to settle debenture holders and creditors fully. That is the issue. Right? So here what happened? Then because of this issue, third-party creditors. Now, first, Mr. Solomon, he said, assets of the company. So the debentures are secured on the assets of the company. Therefore, he must be given the preference while settling the creditors. He must be given first choice. But the third party creditors say no. Right? He is the owner as well as the debenture holder. Right? Therefore, right, we must be given the preference while settling the creditors. Right? Because now the creditors, Mr. Solomon's argument is these debentures are secured on the assets of the company. Therefore, the preference to be given to me. But the third party creditor says, no, preference to be given to us. The reason is very important legal theory they have introduced. Not accurate. They have introduced. This is the legal concept. That is, there's a legal concept. What is the legal concept? This is the concept. This is the concept. No one can owe money to himself. One can ණය Amanta Pulanda Tamantama ණය I can owe to you. I can owe to you. I can owe to myself. Right? Yeah, this is the concept. This is a legal principle. No one can owe money to himself. Money to himself. Therefore, the third party creditor said, in fact, Solomon and the Solomon Company Limited is one and same person. One and same person. Therefore, based on this legal concept, right, we must be given credit because Solomon and the Solomon Company Limited is fact one and same. Right? One and same is the owner as well as the director, right? Therefore, one and same person. There's no difference between Solomon and Solomon Company Limited. One and same person. Therefore, according to this legal concept, no one can owe money to himself. Right? We must be given credit. That is the argument made on behalf of the creditors. Right? Solomon argument is this argument is the debentures were secured of the assets. Therefore, he must be given credit. They said no. Solomon and Solomon Company Limited one and same person. Therefore, based on this legal concept, we must be given credit. So now the court has to decide whose argument is correct. Right? So that is the main issue. Right. First time in the legal history, court held after incorporation of a company. Right. Mr. Solomon is a one person. This concept is correct. This is correct. This legal concept is correct. But court held after incorporation, Mr. Solomon is a one person. Solomon Company Limited is another person. Therefore, after incorporation, there are two persons. One is legal, one is natural person. Therefore, there are two persons there. Therefore, Solomon can give money to Solomon Company Limited. Right? Therefore, actually, if the debentures were secured on the assets of the company, Solomon must be given to them. Right? Separate legal personality concept. Right? First time in the legal history, recognizing this Solomon versus Solomon Company. Understood? Right? So there is the case, first case. And thereafter, right, we are learning about this concept. Like after incorporation, the company is separate from those who own it, create it, own it, and improve it. So this concept, right, introduced in this case, Solomon versus Solomon Company. Right? So, because of this concept, separate legal personality, for the activities of the company itself responsible. Third party cannot file an action against the shareholders, directors, co-promoters. Understood. However, now we can move on to next step. So this is the concept, separate legal person, which is named as corporate A. Corporate B. But however, right, we can identify some exceptions. Exceptions to the corporate thing. Right? We have recognized the concept called separate legal personality. But there are some exceptions. Right? There are some exceptions recognized. There are some exceptions. Right? Now, Amal, Vimal and Amal. I told you, incorporate a company ABC private limited. Third party cannot see and cannot see who are the owners. Who are the owners of the company? Who are the promoters or directors? Because of the deal. Right? Exceptions means now we are going to lift the veil of info. Right? We can lift the veil of incorporation. Once we have lifted the veil of incorporation, then what is the result? Third party can see who are the owners, who are the directors, who are promoters of the company. Lifting of veil of incorporation is named as exceptions to the separate legal personality concept. Or we can say lifting of the veil of once we have lifted the veil of incorporation, then we can identify who are like behind the veil, right? Lifting of veil of incorporation. Veil of incorporation. Lifting of veil of incorporation. Or exceptions to the separate legal personalities. Both are same. Right? In other words, lifting of veil of incorporation means we are going to make these persons, directors, shareholders, and promoters responsible for the activities of the company. Right? Lifting of veil of incorporation means, right? We are going to make these persons responsible. Right? We are going to make these persons responsible for the activities of the company. Therefore, for the activities of the company, these persons are responsible. So these are right occasions we are going to recognize under exceptions. Right? For lifting of veil of incorporation. According to the general concept, for the activities of the company itself responsible. Company itself responsible. But once we have lifted the veil of incorporation, it means for the activities of the company, right? Shareholders, directors, promoters are responsible to the third party. Then actually the third party can bring an action against the right ABC, right, for the activities of the company. Right, so these are exceptions to the separate legal personalities. The thing is how we can lift the veil of incorporation. Under what circumstances we can lift the veil of incorporation. That is the next. Right? That's the next thing that we have to consider. Right. So when we consider the lifting of veil of incorporation, we can lift the veil of incorporation by two methods. Right? One is we can lift. The lift the veil of incorporation. Lifting of veil of incorporation. So we can lift the veil of incorporation by two modes. There are two modes. One is according to the sections, according to the sections of the company's head. According to the sections of the company's head. Right? Or we can say under company set. Company set. Company set. And the second mode is according to case laws. Now in corporate law, these case laws are named as common law. Right? Another very important point is that these case laws are named as common law. Under business law, we have discussed about the common law. What is the common law of Sri Lanka? Roman Dutch law. Roman Dutch law. That is the law which is applicable to most of the people in the society. In that sense, Roman Dutch law is the common law of Sri Lanka. But in corporate law, common law, it refers to judgments, decisions of the higher courts, judgments. So it is named as case law. Right? Judgments of the higher courts, decisions of the higher courts. Common law. So we can say common law principles. According to common law principles, we can live the way of incorporation. And under companies act, we can live the way of incorporation. Right? Based on subsections, we can live the way of incorporation, and right, we can make responsible directors, promoters, shareholders responsible for the activities of the company. Right? We can make them responsible for the activities of the company according to sections. Right? In the company act. Right? First, we can consider the sections. Right? One is now, suppose like this. Now, the company, there is a company. The name of the company is ABC Private Limited. It is a company. Right? Name of the company is ABC Private Limited. A and B, they are directors of the company. And this company has issued a check to another person called White. Right? On behalf of the company, right? This check is issued to White. This check is signed by two directors, A and B. Only two directors signed. Right? On behalf of the company. On behalf of the company, two directors signed. Right. However, the name of the company is erroneously mentioned as BSAA Private Limited. The name of the company is erroneously mentioned on the check. Right. The actual name is ABC Private Limited, but A and B signed the check on behalf of so-called BC Private Limited. There's no such company. The actual name is ABC Private Limited. Her name is erroneously mentioned on the document. Right. Right. Now, suppose the company ABC Private Limited refused to admit this liability. Responsibility of the chain. Then who is responsible to pay money? If the name of the company is erroneously mentioned on a document, which creates a responsibility on the company, and if the company refuses to admit that responsibility, then who is responsible? Who is responsible? Right? Right? Who is responsible? If the company refuses to admit this liability, then who is responsible? A and B. Directors of A and B. It is signed the person or persons, right? Who has signed the document is personally responsible to the third party. Right? Now, suppose the check is given to us, the check is disordered. Then actually, if the company ABC Private Limited actual company, right? The real company, refuse to admit this liability, the person who signed the check is person responsible for it. So in other words, in order to recover money, Y can file an action against A and B. A and Amal and B. Y can, the party can file an action against A and B in order to recover the money. Right? Because the check is dissolved. So if the company refuses to admit the liability, then the person who signed may be employed of the company. Right? Suppose the check is signed by the accountant, then he is responsible. The company refuses to admit this liability. Right? So this is lifting of veil of incorporation. Right? Because for the activities of the company, A and B are personally responsible. The accountant is personally responsible. In the document is signed by the accountant. Understood? This is actually, it is mentioned, right? Mentioned in section 12 of the Companies Act. Section 12. Right? If the name of the company is erroneously mentioned on a document, then if the company refuses to admit the liability or responsibility, then the person who has signed, director, right, officer of the company, right, is personally responsible on that document. Is personally responsible. Right. So this is section 12. Another example, we can list the veil of incorporation. That is, this is a mother company and subsidiaries. S1, S2, S3. Because there are 3 subsidiaries: mother company and subsidiaries. Right? So according to Companies Act, mother company, right, must prepare group accounts for the entire group. Right? Right? Mother company has to prepare group accounts for the entire group. Now, when we consider mother company is a separate legal person. Right? Separate legal person. And S1 is a separate legal person. S2 is a separate legal person. Subsidiaries, right? Subsidiary 3 is a separate person. Right? Can mother company prepare group accounts for S1, S2, S3? Can't, because they are separate persons. Then how mother company can prepare group accounts? Right? So in here, for the accounting purpose, right, mother company can list the veil of incorporation of subsidiaries. And mother company can treat each subsidiary as an economical unit. Right? Then based on that, mother company can group accounts for the entire group. So without listing veil of incorporation, mother company cannot prepare group accounts for the entire group. Right? So that is another example for lifting of veil of incorporation. Right? Under Companies Act, mother company can lift the veil of incorporation of the subsidiaries in order to prepare group accounts. Right? Mother company again, separate person. Subsidiary S1, S2, S3 group accounts are that variant. Veil of incorporation, right? That is actually for the purpose of accounting purpose. And mother company can lift the veil of incorporation of subsidiary. Right? Another very important section mentioned, that is, this is duty on bankruptcy. So duty. Right. But they can, 290, right? Section 290. Right. Very important. Section 290. Now, according to this section, it says a director came to know that the company unable to pay its debts in its ordinary course of business. Director came to know company unable to pay its debts in its ordinary course of business. That is the meaning of bankruptcy. Unable to pay its debts in its ordinary course of business. Then immediately, no time, immediately, promptly, like this director must hold board fee. Board fee. This is the duty of the director. Very simple duty. මොකක්ද එයා කරන්න ඕනේ? මේක දැනගත්ත වහාම board meeting එකක් කරනවා. Right? The director came to know company unable to pay its debts. Immediately, he must call the board meeting. Actually, there are two types of meetings in a company. Later on, I will discuss. Right? Board meeting and shareholders meeting. Shareholders meetings are named as general meetings. Right? But here, it is with regard to board meetings, directors meeting. Board meeting is directors meeting. Right? What a shareholders meeting. Right? සමාගමේ අතර රැස්වීම කරනවා අධ්‍යක්ෂකවරුන්ගෙන් තියෙනවා කොටස් දෙවියන්ගේ රැස්වීමක් වර්ග දෙකක් කරනවා දැන් මෙතන යන්නේ කෝඩ් අධ්‍යක්ෂක මණ්ඩලයේ රැස්වීමක් කරනවා immediately he must call board. If he fails to do so, then as a result of company continues its business, then thereafter liquidator, this director, right? This director who has defaulted in this duty is personally responsible to the creditors. That is according to 219 of the Companies Act. This director is personally responsible to the creditors. This director is personally responsible to compensate the creditors. He is responsible to pay damages to the creditors. Personal responsibility imposed on this director. Right? Who did not comply with the duty mentioned under section 290. But only thing is he must immediately call a board meeting. If he fails to do so, then as a result, the company continues its business and liquidator. This director is personally responsible to compensate the creditors. Creditors can file an action against the director in order to recover damages. Right? For the activities of the company, this director is personally responsible. Personally responsible. Another right example for lifting of bail of incorporation. For the activities of the company, right, director, officer of the company, right, for promoter, shareholder, right, responsible. That is named as lifting of bail of incorporation. So here also, for the activities of the company, this director is personally responsible. Right, personally responsible. So these are three examples, right? I have mentioned, right, under Companies Act. Right, so according to Companies Act, we can lift the bail of incorporation. And the second code is according to case law. So under common law, case law. Right? When we consider the facts of the case, A, employer, right? B, is an employee. Employer and employee. Right? They had an agreement. Right? They had an agreement. According to their agreement, right? This is between employer and employee. Right? Both sides will be. According to this agreement, right? Employee worker cannot engage into contracting customers of employer after his service is terminated. There's a restriction imposed on the worker. What is the restriction? He cannot contract with customers of the employer, right, after his service is terminated. After his service is terminated. Right. Understood? Right. So, suppose these services terminated. There are several reasons service may be terminated. Then thereafter, we cannot engage into contract with customers of the employer. Right. There is a restriction according to their agreement. Right. Now, okay, he agreed that he engaged into this contract. Agreed. Right. Then what happened? Then for a reasonable period, he served for the employee. Right. Then he identified who are the main customers of this employee. He identified. Right. Then thereafter, he resigned. He resigned. And he incorporated a company. He resigned from his appointment and he incorporated a company. Then what happened? Thereafter, he engaged into contract with the customers of the employer. Customers of the employer, right? Through the company. Through the company. Because according to the agreement, he cannot engage into contract with customers of the employer after his service is terminated. Therefore, in order to evade this legal consent, legal barrier, he incorporated a company. Then through the company, he engaged into contract with the customers. Right? So we can identify this company, right? It is treated as a puppet company. Puppet again, who can have puppet? Sham company. Another sham. Puppet. It's a puppet. Guru take a kato, एक आहारा, और मैंने दिए एक. It's a puppet company. Right? Sham company. Right? Sham क्या है? अपने बेसा लागत. Guru किक करके. अगले ही तो भी नहीं. अपने ये कंपनी का ना हटा. तो लागत ही हटा है. तो आना तो चले. ताकि करना है शुभ ना. So this is a puppet company. Then what happened? The employer came to know about this person, right? Who is the main shareholder of this company. Through the company, he engaged into contract with my customers. Right? Then what happened? A employer filed an action against the company. Then actually, in order to identify who is the real person behind this company, who is the owner, who is the real person behind this company, won't link the name. Won't link the date of incorporation, then identify actually the owner is the former employer. Right? Then thereafter, the court has issued an injunction against injunction. What I did? Injunction against the company, right? Preventing the company from engaging into these illegal transactions with the customers of the right? An injunction issue against the company, right? Preventing the company from engaging into this type of illegal class actions. Right? What do you mean by injunction? I put a mother cry, I still not apply. What is an injunction? Injunction? මේ corporate law වලදී මේක තව නමක් කියනවා. ඉස්සරහා මේක හම්බ වෙනවා. දැම්මකොට හරියට අවුවේ නැහැ මතකම අල්ලගෙන යනවා. Injunction එහෙම නැත්නම් මේක තව කියන නමක් තමයි another name we can give restraining orders. ඔය විභාගේ අහලා තියෙනවා. Restraining orders. Restraining orders. Or we can say injunction. Restraining orders or injunction. Both are same. Right? Restraining order. Injunction. What is an injunction? This is an order of the court. Order of the court. Order of the court. Preventing a person from doing, preventing a person from doing an act. Now here, the company is engaging in a contract with the customers of the FT. That is the legal activity. The court can prevent it. Right. So this is an order preventing a person from doing an act. This is named as an injunction. Injunction. Or restraining order. Right? Under a particular topic, we are discussing about the restraining order. There actually what happened, the company is going to engage into conduct which is violating the company's act or the articles. Then shareholders can prevent. Shareholders can prevent. Okay, right? We can identify it's a prevention order. It is an order preventing the company from engaging into a transaction which is violating the company's act. So there we name this order as restraining orders. Restraining orders. Right? Restraining orders. Then there's another word we can use. Right? Instead of injunction, it is named as passing of action. Passing of. When we come here, passing order. Passing of action. It is related to name of the company. Name of the company. And the company is incorporated by name. Right? Then subsequently, another company incorporated by name, which is right, identical or similar to the first registered company. Then, first registered company, and American BAT, BAT is the first registered company. Subsequently, another company incorporated by name, BAT. Identical. Name is identical. If the name is identical or similar, then first registered company can bring an action against the second registered company in order to prevent. Right? The second registered company by using one or more words. Right? One or more words in the name of the company. So that action is named as passing of action. Again, we can identify a particular type of injunction. So here, if the court is satisfied, the court can issue an order against the second registered company, preventing the second registered company from using one or more words in its name. උදාහරණයක් විදිහට ඔය කොකාකෝලා කම්පැනි තියෙනවනේ කොකාකෝලා කියලා කම්පැනි This is the first registered company. ඊට පස්සේ ඉන්දියාවේ වගේ ගන්න Pepsi Cola කියලා එකක් පටන් ගත්තා. Pepsi Cola. Their company එක පටන් ගත්තේ Pepsi Cola. එතකොට ඉන්දියාවේ මොකද කළේ Coca-Cola company file an action against the Pepsi Cola company. Right? In order to prevent the second registered company from using the word cola. The cola කියන වචනේ පාවිච්චි කරන එක වළක්වන්න කියලා අධිකරණය කියන නඩු දැම්මා. නඩුවක් දැම්මා. ඇයි ඒගොල්ලන්ගේ නම Coca-Cola? ඒගොල්ලන්ගේ නම Pepsi Cola. So the first company wants to prevent the second company from using the word cola in its අනුර මොකද උනේ කියන පස්සේ ඔයාගෙන නඩුවක් දැම්මා. නඩුව විසිකලා මම පස්සේ කියන්නේ right? Court refused to issue an injunction against the second registered company. I will tell you recently, right? So likewise here, right? So the first company can bring an action against the second company in order to prevent the second company from using one or more words in its name. So that again we can identify it is an injunction. Prevention order, preventing the second company from you, right? By doing an act. Here, what is that? Using words in its name, cola or whatever, right? One or more words. Right? So here, with regard to the name of the company, this type of actions are named as passing off action. Passing off action. Preventing the second company from using one or more words in its name. Right? So we can identify similar words, right? One is injunction, right? Same meaning, restraining. Another meaning, another word, restraining orders, and passing of action. Another meaning. Here also it is with regard to the name of the company. First company file an action against second company to prevent the second company from using one or more words in its name. Coca-Cola එක Pepsi Cola එකට දැම්ම cola කියන වචනේ පාවිච්චි කරන්න බෑ ඒගොල්ලන්ට. හරි cola කියන එක නවත්තන්න දෙන්න කියලා. ඒතර මේ action එකට අපි කියන්නේ passing of action. ඒ බලන්න එතනත් දෙන්නේ මොකක්ද? An injunction. The court can prevent the second company from using these words, preventing these words as part of its name. ඒක නම් මොකද ගන්න එක තමයි කරන්නේ. බලන්න preventing එකක් තමයි දෙන්නේ. Prevent කරන එක තමයි බලපෑම එක තමයි කරන්නේ. හරි right. යම් කිසි ක්‍රියාවක් කරන එක බලපෑම injunction. Then violating the Companies Act, court can prevent it. Restraining order. It is named as restraining order. Preventing the second company from using one or more words, right, in its name. It is named as passing of action. All are prevention orders. So here, court issue an injunction against the here issue an injunction against the company from using from engaging into contracting with customers of the. So here, one reason for lifting of weight of import. So if the company is a puppet company or sham company, then court can lift the veil of incorporation. Court can lift the veil of incorporation to identify, right, who are the real owners of the company, right, real situation of the company. It's also identified, right? So this is the one example on the case law. We can lift the veil of incorporation. Then the second case is, second case, in this case, there was a company incorporated in UK, United Kingdom, England, right? This company incorporated. Right? All the shareholders are citizens of Germany. Shareholders, citizens of Germany. All the shareholders are citizens of Germany. It is incorporated in England. Shareholders are citizens of Germany. Right. Then actually this company has given a loan to a person called X. He is a citizen of England. Citizen of England. This person. Then what happened? He defaults in payments. Then company filed an action against X in order to recover money. Right? Nadu dala dikko me salli ay karaka. Ye puro aise. Yes. Yeah, England. Right. So then while the case is pending, right? Second war, World War starts. Then what happens? The Germany and England, they became enemies of each other. Right? Germany and England, they became enemies of each other. After the war started, like citizens of both countries are treated as enemies of each other. Right. Then the court in this action, court has to decide whether court can give an order in favor of the company. That is the main issue. Right? Can court give an order in favor of this company? What do you think? After war started, can court give an order in favor of this company? Right? Court lift the veil of incorporation. Then identify who are the shareholders of the company. They are citizens of Germany. They are enemies. Then court can give an order in favor of company. Because if the order is given in favor of company, then X has to pay money to company. Then money is received by who? Enemies. Then they can do the more very more than percent. Therefore, court lift the veil and decide no, because of the national emergency, right? X need not to pay money to this company. Right? So another occasion that we can identify, we can lift the veil of incorporation. Court can lift the veil of incorporation because of national emergency. Right? So this is the second example. Here also, court has lifted the veil of incorporation in order to identify who are the real owners of this company. They are anyway, therefore need not to pay money. Right? So that is the second case. Right? So likewise, because of the national emergency, court can leave. Right? Another one is the company is a puppet company, sham company. Court can leave the veil of incorporation. So there are two more. We have discussed about the concept called separate legal personage. That is after incorporation, company is treated as a separate person. Right? Then for the activities of the company itself responsible. But there are some exceptions. Exceptions means right lifting of veil of incorporation. We can lift the veil of incorporation by two modes. One is according to the company statute, right? And according to the case laws. That is about the incorporation. And separate from the person. I have uploaded all the notes. The idea is
பாத்தியம் பாத்தியா இதுல போறேன் சும்மாண்டா
போயிட்டு செடிக்கு அவ்வளவு சஞ்சீவ் ஒரு எழுதிக்கும் போயிட்டா எனக்கு அவ்வளவு அவ்வளவு
50 கல்யாணம் செஞ்சாரு 8000 பெட்டாரா குடிச்சிருக்கு
Yeah.
அது அப்படியே போடுறான் அப்படியே போடு தெரியல பாங்க சார் தெரியுமா சார்
26
வேறனே இது அப்படியே இருக்கு
அட இவர் கோஆபரேட் சொல்லிருந்தா அவ்வளவு
ரெண்டு கோஆபரேட்டிவ் வேற கோஆபரேட்டிவ்
மூவே உள்ள வேணாங்க ஃபர்ஸ்ட் என்ன கோஆபரேட் தான் என்ன சொல்லியிருந்தாரு சொல்லி
வந்து தலைஞ்சதுக்கு அவர் என்ன கைது ஒரு சொல்லு கூட காதல்
எனக்கு ஒன்று தெரியும் ஒரு என்டிட்டில பார்ட்னர்ஸ் 3 பேர் இருக்கா அந்த என்டிட்டில பிரசிடென்ட் கால்குலேட் பண்ண ஆரம்பி வெரிஃபை ஒரு பார்ட்னர் எடுக்கும் அதோட
அதான் சொல்றாங்க
அது மட்டும் தான் எல்லாம் படுத்து இல்ல சார்
யாரு மெடிக்கல் சரி
ஒரே ஒரு பாடம் மெடிக்கல் இது செய்யும் போது ஃபர்ஸ்ட் லைன் சார் இப்போ ஒன்று பண்ண சிஎஸ்ஐ சி மட்டும் தான் எடுக்கலாம் சி மட்டும் தான் மேக்ஸிமம்
பேப்பர் எல்லாம் தானே பேப்பர் ரெண்டு தான்
இன்னும் ஒன்லி
அதுக்கு என்ன செய்யணும் மெடிக்கல் போயிட்டா
மெடிக்கல்
ஒன்றும் தெரியாது நடக்கிற எக்ஸாம்ல நீ ஷிஃப்ட் பண்ண செய்யணும்
சொல்லணும் கொஞ்சம்
மெடிக்கல் இல்லாம
இது இல்ல நான் சிஏ ஏதாவது தான் எக்ஸாம்
ஏய் வாடா உதவி செஞ்சிட்டு இருக்கேன் நாங்க பாத்தியா மாட்டேன் vehicle junction
சம்பளத்துல 2 மாதம் எடுத்தோம் എന്റെ ഫോൺ വാട്സാപ്പിലെ മെസ്സേജ് ഫോട്ടോ ഇത് ചായ കേസ്